had me with my black outfit on, and I had on a headscarf that I always wear outside. When I saw that picture in the midst of what was happening to me, not only on the day that Captain Winfrey, I don't know if she's still captain, but at the time, she threw me a baby shower. Even when I first started working there, I was called out by, I believe, Captain Winfrey. Captain Winfrey
is who we just heard from.
No, that was Grady.
Oh, I'm sorry. Excuse me. That was
okay, so yes.
Lieutenant Grady.
Buckle up, guys. Today we're going to witness a courtroom spiral where tension explodes within seconds. The judge tries to maintain control, but Miss Young immediately challenges authority with confusing legal jargon and interruptions. What starts as a routine exchange quickly turns serious as the judge issues not one, but 2 contempt rulings, stacking immediate jail time. Right from the opening moments, it's clear this is not going to be an ordinary trial.
It's been a minute. I'm trying to remember names, but she threw me a baby shower at the jail. And when I first started walking there, I was called out for the way that I walked. I walked like I'm a model or twitching my butt or something. And that put me on the spot for everybody in 6 North. So there is no way for me to know if it was because of the baby shower, because she invited my mother and father without my knowledge too. And if I had any knowledge that she would do that, I would not have invited my parents there, because I keep my work separate from my family for this reason. My son was in danger. I was in danger. And there was a instance that happened in the car. But
okay, I'm just trying to break this down. Is it your claim that someone from an inmate in the jail or another employee there
that may have
did this sexual assault?
That may have been the one to do. I don't know who the person was.
Where did it occur?
I tried calling DoorDash to get in contact to see if I can get it, because I called customer service. I parked my car, but I didn't lock my doors. I was having issues with the internet.
Let me rephrase. Did this incident happen inside the jail or outside the jail?
Outside the jail, but I was working with Fulton County at the time.
All right, so the objection came, you were asking Lieutenant Grady whether he had some awareness of a baby shower and that sort of thing. Do you have any reason to believe that he did?
Because if he's aware of the baby shower...
No, that's not my question, not if he is. Do you have any reason to believe that he was aware of the baby shower or your sexual assault?
I would think he does know about the baby shower, because they're all connected. They're always talking, having meetings and whatnot. And it was a surprise to me. So it's like, how else would you get my personal information if you maybe talk to my supervisor, maybe talk to my captain? We've had issues in the past as well. Nothing detrimental, but I still need to know where it could have came from. Anybody. It could have came from Captain Winfrey. It could have came from Lieutenant Grady. It could have came from the inmate.
What could have come from them?
If my family was invited to the jailhouse, they could have been followed back. Someone could have been like, here's her information. Because with that situation, me being touched, I was forced to bring whatever they wanted into the jail, because they have a picture of my son. Who knows if the next picture might be him at his daycare or me coming into my house. My father.
Okay. I understand. So any position of the state, I mean, I'm just trying to focus on process procedure here.
Right.
The things that Ms. Young is saying, I think that if she chooses to testify, she can go into them.
I agree, Your Honor. But I think at this point, I don't think there's sufficient basis for her to ask witnesses regarding some type of baby shower. I'm just not clear as to the nexus or the sequence of the events that would make it relevant at this particular point in the trial.
Okay. I agree with you there. What we're focused on is, I mean, at this point, I don't think it would be, maybe this additional, I think you said lieutenant that's coming, may have knowledge of this potentially that she could ask about.
That is the person who threw the baby shower initially.
The person who's coming next?
Yes.
Okay, well, glad we're talking about it now then. All right, well, I think then you can ask this next witness some of these issues. You're going to have to be careful with your phrasing. I think the state's objection to facts, not in evidence, is...
As the proceedings continue, Miss Young attempts to introduce deeply personal and emotional claims, trying to connect past experiences to the case. The judge carefully questions the relevance, focusing strictly on legal facts. Despite her detailed explanations and suspicions about threats and safety, the courtroom remains centered on procedure. The tension builds as her narrative clashes with the court's demand for clear, admissible evidence.
He produced this report and states exhibits 23, 24, and 25, which are the GBI lab test results.
Everything else is going to be held back?
Yes, Your Honor.
All right. I'm going to place the redacted indictment, Court's Exhibit 1, and the verdict form, Court's Exhibit 3 on top of that. And then when we have the consolidated charge as Court's Exhibit 4, we'll include that in the stack. And that will be ready to go back to them when we complete the charge.
And Your Honor, may I place a copy of the oath?
If you've already got it, just make sure you show Ms. Young that before you do so. I mean, it's a bit redundant since it's also Exhibit 1, but all right. So based on what was just said on the record, is there any objection on behalf of the defense as to what would be going back in the jury room during deliberations?
I would say the oath of office. I object to it because that signature, I have to look over my own document again. My signature, if I'm not mistaken, I signed something else. I'm sorry, let me rephrase that. That typed signature, I'm going to have to look at my document and make sure it matches because I'm not sure. I'm not too quite sure if that matches what I actually signed when I started working with Fulton County. And that's all.
Well, if that's all, the objection I'm hearing is to the authenticity of this document and whether it should be considered by the jury. That ship sailed when it was admitted and there was no objection. So those being the only grounds, then your objection is overruled and Exhibit 1 would be going back. Any other objections?
No objections.
All right. So we're holding in place until we have the consolidated version. That's going to take maybe a few more minutes. Are the parties requesting some additional time to prepare for closings?
Your Honor, state's ready.
I just need a brief bathroom break.
Of course. Do you need a PowerPoint or anything else like that?
I do, Your Honor. So what I would do is I would just take my laptop, if I can, with me to the podium, and I'll just conduct the deal.
You're doing the closing?
Yes, Your Honor.
Okay. And you're opening and closing?
Yes, I'm going to do the close. So defense can go first, and I'll do everything at one time.
All right. So the state's planning to reserve their first closing. And so what that means, Ms. Young, is you'd be up first when we come in and begin closing arguments.
Okay.
And so we'll just take 15, prepare what you need to, practice your PowerPoint, and just let the jury know about 15 minutes we'll be ready to go. We'll be in recess.
Thank you, Your Honor.
We are now back on the record. The time is just before 2:05. It's about 15 minutes past when I instructed the parties to be back at 1:50 to begin closing arguments. The state is present. The defendant is not. I've asked our deputies to search the floor. They have not found the defendant. They've also sent someone into the bathrooms.
The courtroom shifts into procedural mode with discussions about evidence, exhibits, and what the jury will review. Miss Young raises objections, questioning the authenticity of documents, but the judge firmly overrules them, emphasizing missed opportunities to object earlier. The legal pressure mounts as both sides prepare for closing arguments, but an unexpected twist is quietly approaching.
She is not in any of those. And we are also now trying to make a phone call. The only phone number we have is to her mother, who had previously conveyed a message for us Monday morning to have her here to start trial. And at this point, we're also going to review security footage to see if she walked out of the front door of the courthouse. But looking at her table, it looks like all of the papers and things that she came with are not here anymore. She left a jacket behind. But otherwise, all of her belongings are no longer here, from what I can tell. And we're now well after the time I told her to come back. She has not been spotted anywhere on this floor. And so I believe that she has now waived her appearance going forward through this trial, and we can proceed even in her absence under our case law. I would instruct the deputies at any point, if she shows up, she should be let in, and she can resume being here But until she does reappear, we're just going to proceed. So, Mr. Miller, are you still ready for closing arguments? Then let's bring back the jury.
Is this for me?
Judge, is this hers?
I don't know what that
This is
is.
jury charges.
Yeah, that's hers.
Yeah.
Your Honor, Ms. Morgan just went to the office, but she's on her way back now.
Okay. Well, I think we can go ahead and just put some things on the record that we need.
I need paperwork out my bag if that's possible.
Okay, one second. Okay.
All right, let's go back on the record. And first, I would like to perfect some information we received while we've been here on break during deliberations, which is that I requested
Thank you.
Lieutenant Lattimore to review surveillance footage to try and help us locate Miss Young, and he was able to see some footage. And so I'd like Lieutenant Lattimore to share with us for the record what he was able to view and what he observed, and then we'll go from there. So you could just describe that for me, Lieutenant Lattimore?
Yes, Your Honor. I was able to review footage of Ms. Young exiting the 136 checkpoint at approximately 1:51. And from the checkpoint, she proceeded down Pryor Street, which is south of us, and made a left at Mitchell and Pryor, and proceeded east on Mitchell up to Washington Street, where we observed her make a right turn. And at that point is when we lost sight of her movement.
And this is all through surveillance footage you're reviewing after the fact.
Yes, Your Honor.
And that's several blocks away from the courthouse. All right. Miss Young, where were you going?
Before I answer that, I previously
Suddenly, everything takes a shocking turn. Miss Young disappears. The judge returns to the courtroom only to find her missing, triggering concern and immediate action. Surveillance footage is reviewed, revealing that she walked out of the courthouse during a critical break. The courtroom atmosphere shifts from tense to stunned as the judge decides to proceed without her, signaling serious consequences.
stated that you were in contempt of justice, because of failure or refusal to proceed in equity under exclusive jurisdiction. Did you not acknowledge that we were in equity jurisdiction?
If there's anything else you want to say, Miss Young, this is your opportunity to have it on the record. But I'm really not interested in getting into a back and forth. So if you had some kind of emergency come up or something else you needed to address, that's what I was kind of curious about. But otherwise, we're going to move on.
I did. I needed something to eat. I haven't really eaten since last night. I'm pregnant and I felt like I was about to pass out a little bit. I did kind of forget what time we had to come back. But I got a call from my mother stating that I was supposed to be back in an hour. So that was what took me so long, because I went to grab something to eat and I was going to come back. But after I got that call, I was like, okay, well, he did extend the time. But there was miscommunication there. So I apologize for that, Your Honor.
All right. So I just want to break that down, which is it's now about 4:30, and I think they found you trying to re-enter the courthouse about 20 minutes ago or so closer to 4 o'clock. And so you believe that you got a call from your mother saying you didn't have to be back for an hour. And I think we called around 2 o'clock because we were trying to start closing arguments, as I'd indicated.
If I can look at my phone records, she called me and told me that I didn't have to be back until an hour because the court, whoever called her. And I've updated my phone number, email address in the Odyssey system. So I'm not seeing why I'm getting reports that you all are calling my mother and my father instead of the phone number I gave.
I think we've put your explanation on the record. You can, and so that's all well and good. However, I've lost confidence that we can expect you to appear on time for court proceedings. So I've revoked your bond. I've issued a bench warrant, and so you will be in custody pending the outcome of this trial. More to the present business at hand. No, it's not your turn, Ms. Young.
Oh, okay.
I do have Court's Exhibit 5, which I've marked and will tender for the record, which is a question from the jury. It states, and is available for inspection for the parties once I'm done reading it into the record, is there any statutory...
Miss Young eventually returns, offering an explanation that she left due to hunger and confusion about timing. The judge listens but remains unconvinced, pointing out inconsistencies. In a decisive move, her bond is revoked and a bench warrant is issued. The situation escalates rapidly, transforming what could have been a minor issue into a major legal setback for her defense.
minimum for possession of a Schedule 1, Schedule 2, or Schedule 4, respectively, where intent to distribute is presumed if you are in possession in excess of such amount, and it's signed by the foreperson. And so if either party would like to, if the state would like to see it, you can come up and grab it, and if Ms. Young would like to see it, deputies can take it to her.
This is a question from all jurors or specifically?
It's from the jury.
Okay. And though you're failing or refusing to proceed in equity under exclusive jurisdiction, you acknowledge that on the record as well?
All right. My proposed response to this would be
Because you can't
no,
deny that injustice.
and that I would just write on the note, no, and that we would refer them to their previous instructions. Technically, there is a presumed amount, but that's for trafficking, and that's not been charged in this indictment. They asked specifically about the intent to distribute, whether that's ever presumed based on the amount. As I understand it, it is not. So I think it would be an accurate statement of law to say no, and then just refer them to their previous charges. Any input? First from the state.
So they say a minimum. Are they referencing a minimum sentence? An amount?
I take the question as a whole. It's a statutory minimum where intent to distribute is presumed. So I know we use minimum in reference to sentences, and that was my first impression as well. But reading it as a whole, it seems to be focused on the evidence of distribution and whether that intent can be presumed based on a minimum amount of drugs. And again, that's where I say the answer to that legally is no. Actually, I mean, it really just says intent to distribute means intent to unlawfully deliver or sell. So maybe the actual relevant charge would be intent generally, which can be shown in many ways, whether it existed from the proven facts before you. It may be inferred by the proven circumstances or by acts and conduct. So actually, maybe what I would do is say no and then just reread the intent charge and then say that they should place no undue emphasis on this charge and only consider it in the context of the charge as a whole.
State agrees, Jones.
All right. Any input from Ms. Young?
Yes. So you are not acknowledging the fact that you're in contempt of justice on the record, being that this is equity jurisdiction?
Anything else?
No, I need an answer because being that I told you that your failure or refusal to proceed in equity, being that you acknowledge the equity jurisdiction, exclusive jurisdiction will constitute in contempt of justice. I've tried to show you as respondent to all complaints and questions because of the legal special relationship that I have paid on this account. I was about to go and e-file it into the system. Are you in contempt of justice?
As jury questions are addressed, Miss Young once again interrupts with repeated claims about jurisdiction and contempt, refusing to align with courtroom procedure. The judge's patience runs out, issuing further contempt penalties. The courtroom becomes a battleground of authority versus defiance, with every interruption worsening her position as the trial nears its climax. Interview 7. The final phase delivers the most dramatic moment. The jury returns a guilty verdict on all counts. Even during sentencing, Miss Young continues her pattern of defiance, refusing to accept responsibility. The judge, clearly frustrated, highlights her behavior throughout the trial before delivering a harsh sentence of 40 years, with 15 to serve. The courtroom falls into a heavy silence as the consequences fully land. Like the video, subscribe to the channel, and we'll see you in the next video.